As administrative tribunals perform adjudication functions, so the very adjudication function, how it is entrusted to administrative tribunals and to what extent and under what law, that we will discuss in connection to their adjudicatory functions. And regarding that, the very power of a civil court is given to administrative tribunal under the Code of Civil Procedure in respect of the matters like discovery and inspection of documents, enforcement of attendance of any person as witness, and the compulsory production of documents and other evidence, and issuing of commissions, and all the proceedings before the tribunals are declared to be judicial proceedings in terms of section 193 and 228 of the Indian Penal Code. It also provides that the tribunal shall be a civil court for the purpose as provided under section 342, section 345 of Code of Criminal Procedure 1973. So provisions have been made for the prosecution of the offences affecting the administration of justice. Thus, application for these provisions have been extended to the proceedings of a tribunal, and these are the provisions for the procedure of tribunals as well as of those which are required to follow in common. They may be observed in the following order: rules of natural justice, including rule against bias and opportunity of fair hearing. These two rules of procedure are indispensable to the administration of justice. So also production of evidence, examination and cross-examination of parties and witnesses, rule of substantive evidence, and also in the same manner basic rules of evidence should not be overlooked by the tribunals. Production of evidence, examination and cross-examination of parties and witnesses are essentially of the procedural guarantee of justice. The rule of substantive evidence means such a procedure which a reasonable man might accept and whereby parties to controversy lead evidence which is both relevant and adequate by an objective standard, and all this empowers a tribunal to perform its adjudicatory functions, and these are possible due to the Administrative Tribunal Act 1985, and that act of wide scope covering the settlement of service disputes of all the central government employees within its ambit. However, some class of persons are not within the scope of the Act, and they are the members of naval, military or air force or any other armed forces of the Union. So also any officer or servant of the Supreme Court or any High Court. or any person appointed to the secretary staff of either House of the Parliament or to the secretary staff of any state legislation, and as regarding its adjudicatory function, we found a difference between the ordinary courts or civil courts from administrative tribunal, and regarding that the very essential distinction between a court and an administrative tribunal is that a judge is trained to look at things objectively uninfluenced by consideration of policy or expediency, but an executive officer generally looks at things from the standpoint of policy and expediency. The habit of mind of an executive officer so formed cannot be expected to change from function to function or from act to act. So it is essential that some restrictions should be imposed on tribunals in matter of passing orders affecting the rights of parties, and the least they should do is to give reasons for their orders. So, in the leading case, Madhya Pradesh Industries Limited versus Union of India in 1966, Supreme Court held that even in the case of appellate courts, invariable reasons are given except when they dismiss an appeal or revision in limine, and that is because the appellate or revisional court agrees with the reasoned judgment of the subordinate court, or there are no legally permissible grounds to interfere with it. But the same reasoning cannot apply to an appellate tribunal, for as often as not the order of the just tribunal is laconic and does not give any reason, that apart when reasons are insisted upon, no particular form or seal of the reason is prescribed. So, regarding that, we found section 6, subsection 7 of the Administrative Tribunal Act 1985, and so also regarding the very formation of other tribunals, as we found, such as the Election Tribunal, the Industrial Tribunal, the Employees Insurance Court, Income Tax Tribunal, Railway Rate Tribunal, and Compensation Tribunal. So also those tribunals such as the Insurance Regulatory Development Authority and the Telecom Regulatory Authority of India try so we found certain tribunals which are formed under the very act regarding constitution and the functioning of such tribunals, as some of them were having their authority and power derived from the very Constitution of India, such as the Election Tribunal. Article 227 of the Constitution provides that Parliament may from time to time by law make provisions with respect to all matters relating to or in connection with election to either House of Parliament or to the House or either House of the Legislature of a state, including the preparation of electoral rules, the delimitation of constituencies and all other matters necessary for securing the due constitution of such house or houses. So to fulfill the objects of Article 2327, the Parliament passed a law called the Representation of People's Act 1951, Section 2, subsection 1, clause B of this act states that tribunal means a tribunal appointed by the Election Commission under Section 86. The tribunal appointed by the Election Commission under Section 86 is called the Election Tribunal. So, the very Election Tribunal would follow the procedures as laid down under Section 90. So also, the very trial is held under Section 88. So, besides that, the Election Tribunal has the powers as provided under Section 92 of the Act, and as regarding Industrial Tribunal means as provided under Section 2 subsection R of the Industrial Dispute Act 1947, and as Industrial Tribunal constituted under Section 7A. So, Section 2 subsection K of the Industrial Dispute Act 1947 provides that industrial dispute means what, and to be determined between employers and employees, or employers and workmen, or workmen and workmen, which is connected with the employment or non-employment, the terms of employment, the conditions of labor of any person. So the very composition of industrial tribunal is provided under Section 7A of the Industrial Dispute Act, and the very procedure to be followed by the Industrial Tribunal is provided under Section 10 subsection 1 clause D. So Section 11 clause subsection 1, and regarding the power and authority of the tribunal, every tribunal shall have the same powers as are vested in civil code under the Code of Civil Procedure 1980. So also, as regarding employees insurance code are established under the Employees State Insurance Act 1948 as per Section 74 of the Act, and also regarding the procedure, it is provided under Section 76 subsection 1 of the Act, and regarding the very nature of the code, the very insurance code, the very Section 75 of the Act provides it, and as such regarding the very appeal, Section 82, and under subsection 1, it is provided under the Insurance Employees Insurance State Insurance Act 1948 and as also income tax tribunals. Their very constitution of income tax appellate tribunal, it is provided under section 2 subsection 4 of the Income Tax Act 1961, and that is otherwise called the appellate tribunal, and as it is constituted under section 352 of the Act, and so also the very power and function of the Income Tax Appellate Tribunal is provided under section 255, and as regarding the appellate tribunal is deemed to be judicial proceeding as within the meaning of section 193 and 228 of Indian Penal Code, and for the very purpose of 196 of Indian Penal Code. So also for the very appellate tribunal deemed to be a civil code for all purposes as provided under section 195 and chapter 35 of the Code of Criminal Procedure 1973, and so also regarding Railway Rates Tribunal, as it is constituted, and all the powers and functions of that tribunal is as per the provisions of the Civil Procedure Code 1908, and as such they are also considered as civil code for all purposes as provided under section 195 and chapter 35 of Code of Criminal Procedure. So also Compensation Tribunal, and under the tribunals under Air Corporation Act 1953, so also Life Insurance Corporation Act 1950, and under several other acts, and such tribunals have the power of civil code in respect of enforcing the attendance of a witness and his examination on oath and affirmation, issuing of commission, compelling any person for the production of any document, punishing for contempt of the court, and issuing of summons. So, the proceedings before the tribunals are deemed to be judicial proceedings. They act judicially on the basis of records and pleadings of the persons in a contest for claim of compensation. And finally, as we found that all these tribunals are act judicially and they perform adjudicatory functions, and in the very list of tribunals certain new tribunals are added, such as TRAI, the Telecom Regulatory Authority of India, then IRDA, Insurance Regulatory Development Authority of India, regarding all matters falling under insurance. So, as per the very requirement of performing adjudicatory functions by the administrative tribunals, so it is concluded as one of the byproducts of an age of intensive government, and in particular they multiply under welfare state. So, at present administrative tribunals are a kind of inevitable necessity due to intensive government and due to the very demands under a modern socialistic welfare state.